Can you tell me if this has been adjourned once already or first time?
Court date was today, gave the new date. So on 6/16, the defendant called and was he called and we gave him all the information for the hearing. He had failed to appear for the plea back on June 15th. So yeah, when this was supposed to be a plea, he's failing to appear again. And failed to appear for a plea reset.
Okay, well, let's go ahead and issue a bench warrant. There'll be $100 bond. Okay, so let's see. Mr. Becker, are you there?
We are.
Okay, and Mr. Steele is with you?
He is. He's right here to my right. Say hello.
Okay. Good. So this is a show cause hearing, People versus Steele, file 215109SM. Mr. Becker is here for the defendant. Ms. Wilson is here on behalf of the people. And my understanding is the defendant, who is charged with a domestic assault, violated his bond by testing positive for cocaine. Assuming there's a violation as well for all the positive THC tests. There were about a dozen of those indicating the presence of THC, but anyhow, what does your client wish to do, Mr. Becker?
Your Honor, you just brought up THC. Hold on a minute. Have you tested positive for THC?
Yeah, but I got a medical card.
Oh, he says he's got a medical.
She's got a copy of it.
It says there's a copy to the bond agency and the court. I assume that's why the only thing that was on the notice was the cocaine.
Yeah, I saw that too. Let's see. Have we had a prior bond hearing because of the THC violations, Miss Odom?
I'll look for you.
Maybe they were addressed already, Mr. Becker. I don't know.
No. I don't see any. Oh. Okay, RX filed medical marijuana card filed back in April. That's why he's not violated.
Oh, okay. All right. So I guess there's a medical marijuana card on file, so we won't deal with that.
Very good.
So what about the cocaine?
All right. I understand he wishes to plead responsible for that.
All right. So, Mr. Steele, you admit you weren't supposed to be using cocaine on bond, and you did that anyway?
Yes, sir.
All right. Well, Mr. Becker, what do you think I should do?
Well, Your Honor, he's been on bond since April. There's been no violations. He's maintaining himself. As I understood, the current violation was he was at work at the end of a day, and one of his buddies said, "Hey, you want to do a line," or whatever they say. And while they were still at work, but before they'd punched out, they clandestinely did this, and the next day he had to test, and so you've got a positive. He indicates he didn't do much. I mean, so I don't know, but I'm unaware of any quantitative analysis from the examining people. Since it's his first violation and he's otherwise doing fine, I'd ask the court to continue bond or issue some nominal sanctions if the court's so inclined, but Obviously, he's towing the line to be out 2.5 months, and he's on a regular regimen of screens. So it's not like he's gotten lucky. So that's what I'd ask the court to do and to consider. He is regularly employed, he's maintaining everything correctly except for this one singular use.
All right, give me a minute here.
Sure.
Well, my concern is that the victim in this case reported that it was the defendant's return to drug issues that caused the problem in this case, if the allegations are true. So, there's nothing I can do about the marijuana, but there is something I can do about the defendant ignoring the no illegal drug conditions, and that is the defendant's going to spend the next 3 days in jail. So defendant needs to.
I'm going to argue the 3 days. I would point out today is Thursday. I'm quite sure. Can I suggest Friday through Sunday so that he doesn't miss work?
You know what? I think missing a weekend is greater punishment than missing work. So, yeah, I'll do that. So he needs to turn himself in by 5 p.m. And I want a discretionary test for drugs again before he turns himself in at 5 p.m. tomorrow. So that means he'd have to get a test between 6 and 8:30 tonight at New Directions, okay?
I went this morning.
He just took one, Your Honor.
Oh, he did? When?
This morning.
Just 30 minutes.
He says a half hour ago. I assume it had to be before 9, but.
Yeah, before 9.
Okay, well, we'll go with that then, and let's hope that that's negative. So, all right, we're all set for today then, and you'll be out sometime Sunday morning then, but turn yourself in by 5 o'clock on Friday, or we'll make it, well, I'll just cancel bond. So, okay?
Thank you, Your Honor.
All right, thank you.
Judge,
Yeah?
I have Noel there yet?
Oh, on,
We have Ryan
Let's see.
Clark, 11.
okay, no, I don't have Miss Mogenberg here. Is she handling that case?
Well, her and I talked today, and we agreed to seek an adjournment. As the court can see, we filed a motion for a bill of particulars, and Noel said she hadn't seen her copy, so she was kind of taken back, and because we hadn't returned the, what do you call it, sheet, nothing
All right,
further.
well, I'm gonna wait till we get a prosecutor here because I haven't seen them log in yet, but let's, so if you want to either log back in or just stay on the line, we'll wait till one of the prosecutors shows up, okay?
Very good. I'll call back in about 10 minutes, Your Honor.
Okey doke.
Thank you.
Yep, thank you.
Bye.
All right, let's go to People versus Jesse Mowers. That's file 204177SD. Mr. Razavy is here on behalf of Ms. Mowers. Are you hearing me okay, Ms. Mowers?
Yes.
Good. So this is a probation violation hearing. Mr. Razavy, have you discussed this with your client, and what does she wish to do?
Yes, Your Honor. Ms. Mowers understands the allegation is that she consumed alcohol on or about May 28, 2021, with a PBT reading of 0.011 and 0.010. She obviously acknowledges the positive PBT, but does not acknowledge consuming any alcohol on or about that date.
Well, I guess I'm not sure what to do with that. Is she going to
So-
admit to the violation then, or?
She's not admitting that she consumed alcohol, Your Honor.
Okay, then we'll have a hearing, I guess. So, Ms. Stanachek, you want to raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
All right, so is it true the defendant was placed on probation for operating intoxicated with an occupant less than 16 years of age on February 4th, 2021?
Yes, it is.
And looks like that was for 18 months, correct?
That's correct. Yes.
And as a condition of her probation, she was not to consume or possess alcohol. Is that true?
Yes, that is true. And she was taking twice daily PBTs on a Smart Start unit.
All right. And have there been any failures of those PBT tests?
Yeah, she had previous bond and probation violations. So on May 28th of 2021, I received results from Smart Start indicating a 0.011 and a 0.010 at 7:36 a.m. and 7:42 a.m. and 7:44 a.m. At that
Okay.
point in time, she quit testing. As they are directed, people are directed that when they test positive on the Smart Start, they're supposed to continue to test until it stops having them test. And Ms. Mowers discontinued testing at that point.
So I see the 04 test at 7:29, then the 031 at 7:33, the 024 at 7:36, 032 at 7:40, and then at 10:30 there's a 0.
Those are her previous violations. Hopefully I didn't say.
Oh, I'm sorry. I apologize. I'm sorry.
Okay.
You're talking
Yes.
about the February 8th date. Okay. So you're saying on May 28th she should have kept testing, but she did not continue to test.
That's correct. Ms. Mowers contacted me and told me that she left for breakfast and then came back and tested after breakfast.
Did she test after breakfast, and was she negative then?
Yes, at that point she was negative. That was at 9:55 a.m., so 2 hours later.
Okay. Did she make any admissions to you about consuming alcohol, or did she deny it?
She denied consuming alcohol and indicated it was due to her working near where a car was being painted, and is indicated to me that would be why she would have tested positive, was because she was near paint fumes. I actually had just acquired this case from Miss Taylor. And so I actually spoke to Miss Taylor and asked her what her thoughts were on her excuse. And she indicated to me that this is a common thing with Miss Mowers, is that she gives these different excuses for all these different positive PBTs that she gets, and that she did not find it to be any more believable than I found it to be.
Okay. Anything else you want to add, Ms. Stanachek?
No, thank you.
All right, Mr. Rasby, any questions for Ms. Stanachek?
Yeah. Do you have the time that she blew the evening before? Because you said she's on twice dailies.
Yeah, I would have to, that would take some time for me to find. I can find it, but
Okay.
we
That's
don't
all
keep
right,
records in the file.
But she didn't miss, right? She did actually blow in the evening.
Yeah, I didn't receive any other misses or positives on Miss Mowers.
And you mentioned three samples. I only see two. Can you tell me what the 7:44 a.m. was? I didn't receive that.
Yeah, so that was a 0.010. I believe I sent you the whole report. It's a 9-page report from Smart Start. And so basically I documented the first test and then the last test that she did.
Okay. I don't think I got a nine-page report, but that's the pertinent, that's what we're talking about. So that's all right. I don't think I have anything else for Miss Stanichuk. I would like to address, what's being called prior excuse. I know it was a previous bond violation, and we've already addressed that, Your Honor, but I guess I would just allocute from this point forward.
Okay, so you don't have any evidence to present then?
Well, Your Honor, we did submit a letter from Michael Autry, and I don't know, Jesse, is Mr. Autry available?
Yes, he's just in the other of my notes with him.
Okay. Your Honor, I had submitted a letter through the 86th District Court website, a letter from Michael Autry. And apparently he's available to testify. So if you don't have that letter in front of you, I can question Mr. Autry. I also just submitted a Smart Start Michigan ignition interlock device questions, where it lays out, what would be considered a violation for people that use the Smart Start device interlocks, people that are driving and blowing in that device.
What would be a violation? You mean, why wouldn't this be a violation according to that?
So, Your Honor, Smart Start interlock devices are calibrated to, well, for one, no one can consume alcohol and operate a motor vehicle if they're considered a habitual offender and granted restricted privileges using the interlock device. That's clear as day. But the device allows for low BAC readings without interruption. So if you're doing a rolling retest, you're driving your car, it asks you to blow, anything under 0.025 will not lock you out, will not be considered a major violation, will not cause you to get your car recalibrated. So the state of Michigan allows habitual drunk driving offenders the ability to drive with a restricted license using the interlock device without disruption, so long as the BAC is under 0.025. And again, they're not allowed to consume alcohol at all. That's a red line. But with those two things, the state of Michigan is permitting this to occur, because sometimes it's stuff that isn't alcohol that can register. And that's why I submitted that documentation.
Okay,
So,
is there anything else you want to say on behalf of your client? I did receive the letter from Mr. Autry.
Well, I guess I would just call Mr. Autry, Your Honor.
Okay, let's go ahead and do that then. Mr. Autry, is that you with the, he's with Ms. Mowers?
Yes, he was, yes, they are together, Your Honor. I believe she's at work.
All right, sir, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth?
Nothing but the truth, so help me God.
I'm sorry, I didn't understand what you said.
I said in nothing but the truth, so help me God.
Oh, okay. All right, thank you. You can put your hand down, Mr. Rasby, go ahead.
Mr. Autry, were you with Jesse Mowers on the date of May 28th, 2021?
Yes, sir, I was.
And what were you doing that morning?
Painting and working as usual.
And where do you paint at?
Body shop.
And Ms. Mowers was assisting you?
Yes, yes, sir.
At some point in time, did she have to leave in order to provide a sample in her breath test machine?
Correct. Yes, she did.
And when she came back, what did she tell you?
She had told me that she had gotten a violation notice on her machine.
And had either you or Ms. Mowers consumed any alcohol that morning?
No, sir.
And were you with Ms. Mowers the evening prior?
Correct, I was.
And can you recall about the time frame that you spent with Ms. Mowers?
Almost, I'd say close to 17 and a half hours total.
Did you spend the night with Ms. Mowers?
We did stay the night here at the house, yes.
And at any time, did Ms. Mowers consume alcohol on that evening?
No, there's no alcohol in the house.
And did Ms. Mowers blow that evening?
Oh, yeah, she did.
Do you know if she blew, were there any issues with a hot blow that evening?
No, nothing. Normal as usual.
All right. So you were with Ms. Mowers the evening before into the morning of May 28th, and at no time did you see her consume any alcohol?
No, sir.
All right. And you were working with paint materials that morning?
Yes.
Do you know is there any alcohol or ethanol in the paint materials that you work with?
In the water-based urethanes that I use it's not alcohol, but it's the other word you just said. It's methanol. Ethanol, sorry.
Methanol. Okay. All right. Thank you. I have no further questions.
Yeah, thank you, sir.
Hang on, Mr. Autry.
Sorry.
Mr. Autry,
He's
Yes,
coming.
sir.
hang on. Ms. Stanichek, do you have any questions for Mr. Autry?
No, thank you, Your Honor.
Okay, I have a few questions, Mr. Autry. It's obvious you live with Ms. Mowers, correct?
Yeah, she rents the basement
Yeah.
here.
You have a dating relationship?
No, sir.
How long have you lived together?
Oh, I would say probably she moved in right after April.
And you work together? Does she work for you?
Yes, she has 2 jobs, actually.
Does she pay rent?
Yes, she does.
And what's the name of the product that you're saying contains methanol?
Yeah, it's a PPG. It's a base coat, clear coat for automobiles, and it's a water base. And they use ethanol. It's how the product dries. Instead of using
What's it
lacquer
called?
paint,
What's the name of it?
it's a PPG. The base coat was a PR4 paint code, Chrysler color.
Okay. And how do you know it contains ethanol?
I've been doing this for 30 years. I went from basically shooting urethane bases, and everybody switched over about 7 years ago to water base. And we don't use, we used to use reducer, which is pretty harmful to a person, but that's the way the automotive industry has been for years. We switched to the water base because the ethanol alcohol evaporates faster and it doesn't do much harm to the environment and or the person shooting it. Unfortunately, they don't offer a water-based clear coat yet, so we still have to use like a high VOC content clear coat, which contains a reducer and or lacquer thinner.
You said you were with Ms. Mowers for 17 hours prior to getting up in the morning and going into the shop, correct?
Right. Absolutely.
All right. What were you doing for 17 hours with Ms. Mowers?
Well, since 5:30 in the morning, we were We were working in the bar or the shop. Prior to that, in bed, obviously she was downstairs.
What? So you were in different rooms, so you wouldn't know whether she was consuming in her room, right?
Yeah, I would. Her children are in that room.
Were you in the room?
Not during a small period of time. No.
All right, so most of that time she was in her room by herself, and then you
No,
went
her
to
children were
work
in,
with her before that.
well, her children were in the room with her.
Okay, I didn't ask whether her children were in the room with her. I asked if you were there and you could see what was going on. She also was intoxicated. Did you know this? She rolled her car with her 2 kids in it. That's why she's here in the first place.
I understand that, Your Honor, but you said she was
Are you
alone.
saying she doesn't drink around her kids?
I'm telling you that she doesn't drink in this house, period. And your question, Your Honor, was that you said she was alone. And I said she was not alone. Her children were in the room. That's all I said.
All right, are you saying she doesn't drink around her children?
I'm telling you she doesn't drink at all.
Would it surprise you to know she rolled her car while intoxicated with about 2.5 times the legal limit with both of her kids in the car? Would that surprise you?
A little bit, yes.
All right, we're done. Okay, Mr. Razovy, any other evidence?
No, there's no other evidence, Your Honor.
All right, any additional argument?
Your Honor, all I would ask is that the court consider the fact that the testimony here today of Mr. Autry is that he did not see her consume any alcohol, that there is not any alcohol in the home, that he was with her the morning of and they did not consume any alcohol. I would ask that the court consider the fact that this is a very low BAC reading, that she tested the evening before. It was clear with no issues. And that Ms. Mowers and I have discussed what she needs to do in the future. We don't know for certain, and I want to be clear, we don't know for certain if it was the chemicals in the paint that set this off. We don't know if it was her GERD. We don't know. We truly don't know. None of us were with Ms. Mowers. We have her testimony or her statements to the fact that she didn't drink. We have Mr. Autry and his words. We do know that these machines do detect other things than blood alcohol that we consume. It tests, it can pick up other materials. That's why they're given instructions as far as what they should and should not do when they blow. To that end, Ms. Mowers and I have discussed, first, if she's going to be working with paint, that she's going to have to wash her hands. If she needs to take a shower, change her clothes to make sure that nothing like this happens again. So there are things she can do to keep this from reoccurring. As Ms. Stanichuk pointed out, she should also continue to test. Sometimes that's difficult because the machine doesn't just allow a sample, like let you test back to back to back. Sometimes there's a GPS issue, or you're not blowing properly, or the light's wrong. It's not as easy as it may sound, but regardless of that, she has to continue to test because that's going to be the only way to clarify this. We used to be able to address these with ETGs. Ms. Mowers tells me that she was told from her last probation officer in no uncertain terms that an ETG would not be considered. I understand that's the court's policy, but an ETG within 24 hours might have been able to give us certainty on this issue. And then finally, as I've indicated, had Ms. Mowers been under the rules of a habitual drunk driver with an interlock device, she could have been driving with twice this limit without any repercussion. I mean, we're talking about a very low sample here. And I know that the court's in a tough spot because you've got a violation, it's positive, and you deal with it that way. But the reasoning behind this leeway that the state has is because there are things that are detected other than blood alcohol in these breath samples. So with the reading being so low, and with Mr. Autry's testimony, I would ask that the court consider that and not impose the additional jail time on this violation.
All right, thank you, Mr. Rasby. Ms. Stanichuk, is there anything you'd like to add?
Just, Your Honor, that we are not here right now to determine if Mrs. Mowers violated the ignition interlock rules. We're here to determine if she violated the probation rules that were set forth. And just the fact that she walked away without completing her testing, defendants are told that that acknowledges a violation at that point. So we have positives, and we have a defendant who walked away from the machine before she was zeros. Nothing further, Your Honor.
All right, well, the standard in a probation violation hearing is a preponderance of the evidence. And what we know is that there was a positive reading on a preliminary breath test. It was a 0.011. I would note that that is, and a 0.010 a few moments later. And then the defendant stopped testing, which Ms. Stanichuk states that walking away without further testing would be an indication that the defendant did not want to further incriminate herself. And I find that to be helpful in determining what happened in this case. I think it's also helpful to know that Ms. Mowers has, in the pre-sentence report itself, she reported that she was having difficulty with her Smart Start because of drinking an energy drink and also brushing her teeth using Listerine. So Ms. Stanichuk testified that her prior probation officer reported that there was this history of giving excuses that don't make any sense as far as the testing results. And a 0.011 may seem small, but a 0.015 is equivalent to a standard alcohol content beer or a regular sized glass of wine. So we're talking about 2/3 of that amount. And it is the experience of this court that it is not uncommon that defendants with an alcohol problem, and we know that Ms. Mowers has I think it's severe alcohol problem according to her substance use assessment, that she, sorry, I lost my train of thought there. That they will consume alcohol hoping to sober up just enough to pass the test and get around the testing. And that's why these lower numbers are important. It's also important that this court will take judicial notice of the fact that all defendants placed on probation with these terms and conditions are told that they need to be careful around any types of products that might contain alcohol. I find Mr. Autry's testimony today here suspect. First of all, he lives with Ms. Mowers. Apparently they work together. He said he spent 17 hours with her the day before. He did not answer questions that the court asked. He volunteered information instead, such as suggesting that because she was around her kids, that she would not have consumed alcohol, even though he clearly was not with her for the period of time that she was in her room sleeping, supposedly. So his testimony is, well, there's bias there, there's interest. It may be that he needs Ms. Mowers to continue paying rent, or wants her to continue to be employed at the shop or whatever. But the fact that he shows up in her home where they live together, I did not find the testimony of Mr. Autry to be credible. We also know that this is a defendant who multiple times on bond and probation has tested positive. And, you know, some of these readings were 09s and 03s and 04s. There were lower readings, 0.01. But the fact is that all of that together is overwhelming evidence that this was a violation of the defendant's bond conditions. Excuse me, probation conditions. Particularly coupled with the fact that this is a defendant who has a serious substance use issue. So then the question becomes what to do about it. The recommendation is for the defendant to serve 5 additional days in jail to disclose to Catholic Human Services the violation, follow all recommendations, and continue all other conditions of probation, and the $125 court-appointed attorney fee. I'm going to follow those recommendations, and I'm just going to say to you, Ms. Mowers, I don't believe for a minute what the explanation was here. I didn't believe the Listerine. I didn't believe the energy drink. You know, if rolling your car and placing your 2 kids in jeopardy of being injured isn't enough to wake you up and make you want to do something different, to be honest about your alcohol problem, I don't know what else can do it, but maybe 5 more days in jail will. So you need to turn yourself in this afternoon by 5 p.m. and we're all set for today. Thank you, Mr. Lasby.
Thank you.
All right, let's go to the preliminary examinations. We've got Ms. Roberts here for the prosecutor's office. Is Ryan Clark present, or Mr. Becker?
David Becker here. Ryan Clark is with me in my conference room. We're on speakerphone.
Oh, okay. So Mr. Becker has indicated that he's requesting an adjournment because he's filed a motion. What sort of motion did you say you filed for discovery?
Motion for a bill of particulars.
A bill of particulars. Okay. So, Ms. Roberts, what's your position?
Objection to that, Your Honor.
Were you aware of the bill of particulars? Because Mr. Becker had indicated he discussed this with Ms. Mogenberg. And Mr. Becker, did you have some agreement with Ms. Mogenberg, or did you just mention it to her?
I left a message this morning. She called me this morning, and she indicated that she also sought an adjournment because they had not brought any witnesses, and she had not seen the bill of particulars. And I read to her the email address that had been sent to, and I guess it was Tina Len that it was sent to. So she was going to go track it down, and we're going to re-email the motion to her again, just to make sure. But I show the court was mailed, I believe, a proof of service, 86th District. No, email.
All right. Well, I guess the first question is, Ms. Roberts, do you have witnesses here to testify today?
No, Your Honor, we did not get the PCC form back, so we did not subpoena any witnesses. And looking at the file, we do not have a copy of that bill, but, you know, certainly this line.
Oh,
But no, we did
I'm
not. get the
sorry.
PCC.
you're not objecting then to the adjournment?
Nope.
I'm sorry, I misunderstood what you said. I thought you said you were objecting. So, okay, so we'll go ahead and adjourn this out then. Will we need to take up the bill of particulars at some point as a separate motion? Or, yeah, go ahead, Mr. Becker.
I'm going to assume just on the face of the motion that the prosecutor will agree that we're entitled to just a little bit more information than simply reciting the CSC language.
Okay, well, if the prosecutor disagrees, then I guess they'll file a response and we'll set it for a hearing. But for now, let's go ahead and pick a date. Let's say, you think 2 or 3 weeks out, Mr. Becker?
3 would be probably more, I think 3 will be satisfactory.
Okay, you agree, Ms. Roberts?
Yes, Your Honor. Yep.
All right, well, given that the prosecutor will need to respond to the motion, that makes sense. So go ahead, Ms. Odom.
Do we need an afternoon or 11 o'clock?
Mr. Becker, do you think this is likely to be a hearing?
It's unlikely.
Unlikely. So we'll just set it for 11 o'clock then.
All right, Judge, how about July 29th? That's a Thursday, 3 weeks from today.
All right, I do need to make sure that your client is agreeable to the adjournment. Mr. Clark, do you understand you have a right normally to have your hearing within 21 days of the arraignment or 14 days of the probable cause conference? That's obviously not going to happen if the case is adjourned, but that's what your attorney is recommending for you. Is that what you want to do?
Yes, sir.
Okay. Is there anything else we need to take up today?
No, Your Honor.
That covers it all, Your Honor.
All right. Well, thank you. And we're all set for today.
Very good. Thank you, Your Honor.
All right. Let's go to People versus Sylvester Neal. That's file 215434 FY. And Mr. Connolly was here. There he is. And is your client present, Mr. Connolly?
Your Honor, Mr. Neal is in the Grand Traverse County Jail.
Wow. So we'll get him dialed up here.
What about that?
Ms. Blue is here for the People. And let's see, are you anticipating a hearing this morning, Mr. Connolly?
Your Honor, I was anticipating a hearing, but it sounds like the prosecutor is going to request an adjournment. I had called the prosecutor's office indicating them would be held. That was not related to Blue. I'm sorry, new different name to the prosecutor. So I don't believe she has witnesses. I do have a witness that could go this morning, but I don't believe that she does. So that's the Your Honor.
All right. Do you need to speak with your client about the adjournment before we get started?
Yes, that's probably best, Your Honor. There's also a bond review hearing I received notice of for this morning.
Okay. So, well, we'll be in recess. Ms. Odom will put you in that breakout room with the jail, and she'll also let me know about what the bond violation is about.
Yeah.
That wasn't on my docket. So
That's because this is a long story. And I actually forget. This got moved from Judge Stepka's docket to our docket because it's our case. And we have a bond hearing, I think, set on the 23rd, but we should take it up today since we're
here.
doing
Okay.
this. Yeah.
All right. So we'll be in recess until then.
Moving on.
Thank you.
Sorry, Ms. Roberts. It's going to take me a little time.
It's all good. You're not the first one, and you will be the last.
No, the judge flip-flops back between Blue and Roberts. Have you noticed that?
I did, yeah.
It's all right. I answered to Mr. Con.
Yeah, there you go.
Can I take?
Yes, please. Thank you.
Can I-
Matt, you're going in and out again. I don't know why. What did you need?
For some reason, it's only in when I have Judge Cooney, like, because I don't have that issue with any other Zooming.
Really?
Yeah.
Well, what the heck?
See, now you
don't know.
sound fine, but when you first started
Yeah.
talking earlier, you were cutting.
I just hold it closer, and it seems to work a little better. We'll get there.
Okay, well, thanks.
I did get
Alright.
that report. Thank you, by the way. So
Oh, yeah.
So, Matt, do you know what the violations are?
I believe the allegation is that there was contact with the victim and that he was violated the proximity. So his tether was
Okay.
alleged to have been within the 500 feet or within the
All right, I'm
area.
looking.
Tammy, do you know if you have a copy of the police report that references
Oh, gosh.
the bond issues?
I need to look here. Let me look.
And also, just so you know, Whitney, the alleged victim in the case, she's present as well. So the last four of her phone number are 4454.
Okay. Thanks. All right, let me see what I can find here. Complaint.
Oh, she's got herself named anyway.
Oh, good. Oh my gosh. I don't have a copy of that.
Do you want me to forward
Violation,
the email?
Victim home exclusion zone alert. Oh, sorry, I do have this thing. This is just like an email is what I thought it was.
So there's
Yeah.
actually a few different references. There's a community corrections violation, which is in the ROA. And then there was actually a police report. Somebody called Central Dispatch about the same date and time.
Okay.
So I'll forward that to you. And Mr.
You know, I have the, when you said police report, I went to the right tab. I've got that. That happened on, this has got it, 6:15, right?
I believe it's the 23rd. Let me check.
Should be, let's see, 623.
Oh. Report 621, but this says on 6:15 at approximately 17:35 Central Dispatch, blah, blah, blah. Is that not the right one?
That's the actual police report for the underlying offense.
Oh,
So I will forward you the violation report.
all right. Let's see.
Mr. Connolly does have a copy of that. I forwarded that to him this morning as well.
Okay,
Yeah.
so sure, that'd be great. And then I'll print out the other thing for him under bond violation, the community corrections violation. Do you have the community corrections violation email Lynn Hildebrand stuff, you guys, or do you need it?
I can use it.
Yeah,
Okay.
as well. I just read the ROA. I didn't have any.
Okay, I'll send this to you. It looks like it's the same thing over and over, but let me look at this. June 23rd. It's 10 pages long. Okay. All right. I'll get it to you in a minute. Oh, and you need a breakout room, huh?
Yes, please.
All right.
Just sit just a little bit. There you go.
There you go.
Tammy, off the top of your head, is there any live action next week?
No, and hang on one second. I gotta print one thing here. Hopefully I've got it. Yeah, hang on. Gosh, I got a hair in my eye. Ugh.
Is that what you were trying to?
Yes, it was driving me nuts.
I can tell.
I know. I'm like, oh. Okay. No, nothing, nothing next week. I'll fill you in. I gotta grab this for him.
Yes, yes.
Okay, that's not what I want. What the heck? All right. Mm. Okay. There it is. Hang on. print type one-sided and a printed double-sided.
Printer settings?
That's where I'm at. Let's see. Print all pages for entire document. Printer, I went there. Goodness, I hope it doesn't do it again. It says it's supposed to be one-sided, printing, and then I went to make a double-sided to one-sided copy so I can scan it in and email it to these guys, and it ate it.
Oh,
Yeah, I'm not having the best time with this right now.
I'm sorry.
It's all right.
Be patient, you'll get it.
I'm like, really?
I know you will.
Really? Let's hope so. She's so cute. Copy it again if it won't work. It's printing a gazillion times in there. Let's go see. Did the printer go off?
Did it work?
I just hit print like 3 times and he's saying he didn't hear it go off. So try it one more time.
Is it in your office?
What's going on here? Yeah,
I'll go check.
thank you. Is it doing anything?
Nothing.
Oh my goodness. Nope, you and I are gonna go and see if you can find it down there. Ms. Blue? Ms. Roberts? You guys are both back? Sorry it took so long yet.
I haven't seen Mr. Connolly back yet.
I just saw him. Are you there? That was really weird. Maybe that was a fluke. You saw it, didn't you? Oh, I know he did. Nope, he's still in the breakout room.
Weird.
That's odd. Okay, so I did send you an email attaching that stuff.
Okay. Thank you. Did you get mine with the police report?
I did, but I was confused because it did have the old police report too, right?
The one
Looks
I
like it had the old. Yeah, when I printed it, I'm like, how did I get this? And then it was behind 2 pages of like the 615 police report.
Oh, weird.
Because I just want to confirm, I don't need that.
It should just be a 3-page report. The first page is the cover page and then 2 pages of content.
What I have is, well, where did I get that? 1, 2, 3. Maybe he or maybe I printed the other police report without realizing.
Oh, could be.
Before I printed yours. Yeah, maybe. Who knows? Okay, yes. To answer your question, yes, I do have that.
Thank you.
Yeah, thank you. I want to make sure. Yeah, I'm going to reprint that too, just to be sure. We ready?
Yeah.
Okay. Did you get my email?
Yeah, I did. Thank you. I didn't realize the level of detail that those tethers collected.
Good.
That's pretty cool.
Yeah, I've never seen it myself.
It actually
When I was
tells you
trying to get, yeah,
how fast they were going.
I know, it's crazy.
Yeah.
We're ready, Judge.
All right, then we're back on the record in People versus Sylvester Neal, file 215434. And Mr. Connolly's here on behalf of Mr. Neal, Ms. Roberts for the people. So let's see, this is a request for an adjournment, as I understand it. Is that correct, Mr. Connolly and Ms. Roberts?
It is, Your Honor. I spoke with Mr. Connolly yesterday. We did not get the PCC form back, so subpoenas were not done. At that time, he informed me that he talked to Mr. Atwood and discussed holding the prelim with him. I discussed that with Atwood. He didn't have any recollection of that conversation. Certainly not saying, but nonetheless, we didn't get the PCC back, so subpoenas were not completed.
All right, so Mr. Connolly, what's your position?
Your Honor, my client would like to hold the prelim obviously today, but again, I understand the issue the prosecutor had. I did call and speak with Mr. Atwood to let him know that it was going to be held, so not sure what happened. We do have the victim is present.
Is that correct? The probable cause form was not returned then?
It's correct, Your Honor, because Mr. Neal was back in jail so quickly. I didn't realize until I got a call from Mr. Hubble, who was the MIDC attorney in his arraignment, that he had been placed back in the jail based on these bond violations so quickly after being released. So.
Okay. All right. Well, I will grant an adjournment for cause, because the prosecutor does rely on those probable cause statements in determining how to proceed. And there's good reason for that. And it's a requirement under the court rules. So we will expedite the hearing, however, given the fact the defendant is in custody. Let's see. So Ms. Odom, why don't you work with Mr. Connolly and Ms. Roberts on a date for that hearing?
Okay. Ms. Roberts, how much time do you need for subpoenas?
A week should be fine.
Okay.
I mean, technically it's not, I think 10 days is the actual requirement, but I think based on, wanting this done quickly, a week would work.
Okay. And do we need an afternoon?
I don't think so.
No.
So I can do a day less than a week. I can do Wednesday, July 14th at 11.
That's fine for me.
Okay, so we'll be back on that date for the preliminary examination. Are there other issues we need to take up, Mr. Connolly?
Your Honor, yes, there's the issue with respect to my client's bond. I believe this was initially set for a hearing on the 23rd, but Your Honor, and the court has graciously agreed to hear it today. Mr. Neal, his bond was violated and he was placed back in the county jail based upon allegations that he had contact with the victim in the matter and that he violated his proximity alarm. I do have a printout provided to me from the GPS tether that does show that he was within King's Court, and Mr. Neal will acknowledge that he went into King's Court to pick up his son. With respect to contact with the alleged victim, we would dispute that, Your Honor, and the alleged victim is here via Zoom for this hearing to provide any testimony as to whether or not there was contact.
Okay, so do you want to call her as a witness then?
Yes, Your Honor.
All right, so is it Miss Whitney?
Yes, I'm here.
Yeah, could you please raise your right hand and tell me when you've done that?
I have it up.
Okay, are you able to turn your camera on so that I can see your face as well?
Yes.
All right, do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
All right, put your hand down. So go ahead, Mr. Connolly.
Thank you. Could you please state your name for the court record and spell your last name?
Whitney Antonio Aguirre. My last name ANTONIO-AGUIRRE.
Miss Antonio Aguirre, on or about June 23rd, did you in fact have contact with Mr. Neal, Sylvester Neal?
No, sir.
Did you pick him up and give him a ride?
No, sir. I was actually working that day.
Okay, where do you work?
I clean Airbnbs and I work at a dog foster care home, but I was cleaning Airbnbs that day.
So you're since Mr. Neal's released from the county jail, have you had physical contact with him?
No, sir.
Have you had telephone contact with him?
No, sir.
Right. Did you in fact block the jail phone from calling your?
Because I didn't want no issues for him to possibly get into trouble, but yeah, it is blocked.
Okay. Do you know if anybody else may have given him a ride on the 23rd?
My friend Lacey, I believe.
Okay. All right. And no further questions, Your Honor. Thank you.
All right, Ms. Roberts, do you have any questions for the witness?
No, Your Honor.
All right. Thank you, ma'am. Mr. Connolly, any other evidence?
Just some, not testimonial, Your Honor, but there are some other things I would just inform Your Honor about as to why Mr. Neal did that.
Okay, go ahead.
So, Your Honor, Mr. Neal's son was there, not common with the victim, but his son was in the park. He called his son on his son's cell phone and was arranging to pick him up. That's why he got a ride from another individual named Lacey J. Turner in order to pick up his son from the park. He did finally pick him up, and the next day they were preparing to head down to Detroit, where the mother of Mr. Neal's other children, the siblings to his son, had passed away, and there was a memorial service to be held. Unfortunately, because the tether sensor went off, Mr. Neal was arrested that morning and was unable to attend the funeral. So, not the funeral, I'm sorry, the service, Your Honor. So that's why he was there. That's why he picked up his son. He did not have contact with the alleged victim in the case, was not in her residence, did not call her. All communications were with his son, and was in fact planning to drive down to Detroit that next morning. And Miss Turner was in fact the person who was going to drive him to Detroit. It's my understanding that Miss Turner is still prepared to drive him down to Detroit in the event he can be re-released on bond. He wishes to be down there with his children. He has not yet been able to interact with them since the passing of their mother. So understandably, Mr. Neal's family is a bit frustrated with him over that, and it's been hard on Mr. Neal as well. So I'm asking that Your Honor consider reinstating his bond with the condition that he, as soon as possible, preferably tomorrow, or if he gets out or today, as soon as Ms. Turner is available, drives himself or has himself driven down to Metro Detroit, Your Honor, where he will be residing until the pendency of the matter is concluded.
Okay, Ms. Roberts, anything for the people?
My only, I guess, evidence or position on this would be based on a bond violation police report that was submitted to my office. In that report, there was a call and concern that the defendant was with the victim. Deputies responded to the location, attempted to make contact, were not able to with the victim. They did make contact with the victim's children. And both of those children advised that the victim had gone to pick up the defendant, had called the children saying that he needed to be let back into the apartment residence to pick up his belongings. They were upset with her that she was back with him after the original incident had occurred. So I think once the actual prelim is held, this court will find that the victim is not said anything has happened throughout this entire case. There were other witnesses that intervened and actually are the complaining witnesses on this case. So I don't think I know this court knows this is not atypical of a victim to say nothing happened. So I would ask that at this point, the court keep the bond in place, at least until the testimony is brought out.
And Your Honor, I would point out that the children indicated that Mr. Neal had not been to their residence and that they said their mother left to pick him up. So they did not see Neal with their mother. And the person who made the report is anonymous. In fact, maybe a family member of the victims who is trying to instigate trouble for Mr. Neal, Judge. So I don't think there's much credibility to that report. And again, the alleged victim testified that she was in fact working that morning and did not pick up Neal. So I think we've got some family that's not happy with mom. I think some of mom's siblings are not happy with her choices in relationships. So I think some people are trying to interject or meddle in this, Your Honor. But the fact is that Mr. Neal did not have contact with the victim.
There was a report that I saw in preparation for this where what I thought I read was that the children were interviewed by I assumed it was a police officer who said that, and the children asked why are you letting this guy that just beat you hang around? And she said something to the effect of, well, it's my house, I pay the bills. Have I got the wrong report? Or
No, that's correct report. And I would note too that is the same date and approximately right around the same time that the tether shows a violation of the zones or violation of him being in the zone. So I think that's corroboration with his.
Were the statements made to a police officer, or who were they made to? Because Mr. Connolly's saying something about someone else being involved in instigating.
Those statements by the children were made to Deputy Hendricks. I don't know this other person.
So somebody filed the police report, or somebody called in, Your Honor, and made the allegation that they saw Mr. Neal and the victim together. That person didn't provide their name. That's who I'm suggesting is trying to.
Well, I believe the kids. So the defendant is motion for bond is denied. And, I gave him the opportunity to be out with a GPS device, and he violated. Even if all of this is true, he still violated by going to Rex's place. And he knew that, and he should have known better since he had a GPS device.
This correct.
I thought it showed that he didn't go to Rex's place.
Have I got that wrong, Mr. Connolly, Ms. Roberts?
No, Your Honor. The tether shows that he's within the 500 yards is what.
Right, he's within the alert zone, within the 500 yards of the residence. So, and I don't know where else you would get the child from other than, well, anyhow, it was a violation, and frankly, I believe the kids' statements to the police officers. So anyhow, that's it for today, and we'll see you back for the preliminary examination.
Yeah, we going all the way.
So Odom, was that the 14th? I just want to make sure I have that date correct.
Correct.
Yep.
The 14th.
Thank you, Your Honor.
All right, thank you, Mr. Connolly.